Good afternoon, friends. In this video, I will share whether before approaching Honorable Supreme Court under Article 136 of the Supreme Court Constitution of India, whether we have to exhaust remedies available to us under the Statutory Act or we can directly proceed. If the answer is yes, what are the circumstances where we can proceed with the SLP under Article 136, ignoring other statutory provisions? This is the issue. So, friends, before answering that, we have to read out Article 136 of the Constitution, what it says. It says, notwithstanding anything in Chapter 4 of Part 5 of the Constitution, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. So this is the definition, which is clear that it does not confer a right to the party to appeal to the Supreme Court, but it confers discretion upon the Supreme Court to grant leave to appeal in suitable cases. So it is used sparingly. So friends, this Article 136 does not impose any restriction on the power of the Supreme Court granting leave to appeal. However, Honorable Supreme Court has imposed itself a restriction. Such a restriction is a self-imposed restriction and does not oust the jurisdiction of the Supreme Court. It is the wisdom of the honorable judges of the Supreme Court who are listening to the SLP. Friends, Honorable Supreme Court has held that mere existence of alternative remedy by itself will not take away its special jurisdiction under Article 136 of the Constitution. And the court would not grant, it further says, the court would not grant special leave and entertain appeals against orders, judgments, decree of the district court or court subordinate thereto, if remedy by way of appeal or revision to the High Court or other courts or forum is available. So friends, two types of views are in. On one side, there is no binding upon the court, no bar on the court, but on other side, it is the wisdom of the court to take into consideration the circumstances of the case, whether to allow SLP or not. An appeal by special leave to Supreme Court cannot therefore be considered as an appeal as of right or as an appeal in pursuance of the right to appeal to the Supreme Court. Friends, the word right to appeal refers to right conferred either under the Constitution or under a statute to file an appeal to the higher court against the judgment, decree, or order of the lower court without having to first obtain any permission or leave. Whereas the discretionary power does not bar anything upon the Supreme Court of India. So friends, though the existence of alternative remedy by itself will not take away the jurisdiction of this court under Article 136, this court would not grant leave and entertain appeals against orders, judgments, decrees of the district court or courts subordinate thereto, if remedy by way of appeal or revision to the High Court or other courts is available. The existence of alternative or statutory remedy is a rule of caution for the party invoking the special jurisdiction of the Supreme Court under Article 136 of the Constitution, and at the same time, such a rule does not restrict the Supreme Court in exercising its special jurisdiction where grave injustice has been caused or there are shocking features in the matter. Then it can exercise its special jurisdiction under Article 136 of the Constitution, even if an alternative or statutory remedy is available to the party. So, friends, circumstances of the case allow discretionary power to use or the Honorable Judges of the Supreme Court, taking into other circumstances, may refuse. That's all. God bless you all. Thank you.